Here.
Nice to hear, Faisal, but I think there's something wrong with the sound system.
Okay.
It's coming sporadically. What is this business? Why is it like this? Why is it not text through? Why?
Might set up.
Why is it not text through? This is really the speakers. That speaker. I think it's you. He knows you. It's not here. Faisal, can you say something, please?
Yes, good afternoon. Good evening to everyone.
This audio. This is not connected.
Say something, Faisal. Again, they test the system here. Say something, test the system, Faisal.
Yes, can everyone hear me?
Vipin?
Faisal Sidiqui is
Yes, ma'am.
विपिन थोड़ा जोर से कुछ बोलना आवाज चेक कर रहे हैं
हाँ हाँ sure. Hello, hello. Can you hear me?
Yes, I can.
Okay, all right.
we can hear you, but we can't hear.
Yes, sir.
Connect.
कैसा था अंकल
Your ma'am, your voice is breaking.
Faisal, say something.
Yes, can everyone hear me?
Yes, yes, I can hear you.
So, you just say something. Follow.
Colin is breaking up, but I can hear you.
Yes, sir.
outside everything okay his network
Faisal, ready to go. I must inform you that we have about 30 or 40 people registered separately and listening to you, and we have a room with about 100 people who are looking to a big screen. We could hear you a little while ago, so you do another test. You can say 1 to 10 slowly, and then confirm you again.
I can hear you, Colin, but you're breaking up while you're speaking. Now I can't hear Colin.
Yes, it's taking up. So the let's see. I'm putting off. So I put off my video, and maybe you can put off yours after you say a few words.
Yes,
maybe
I can hear you
Could
now.
you say something, please?
Yes, good evening to everyone. I'm very happy to be here. And when you've put off your video, Colin, I could hear you better.
Yes, yes.
Yes, and Faisal, thank you for doing this. It's lovely to hear your voice. Although I would love to be able to see you, but we are not doing that at the moment because of the network. But as I said, there are about 40 people outside who have registered separately, and we are at a conference in Odisha where we are doing our national meeting, and we have about 100 people in a big room, and they are listening to you on the screen which is in front of us. It's wonderful to be in touch with you again. And on the Center for Constitutional Rights, we are going to do many things together. And I'm grateful to Karamat for fixing up the talk with Munir, which was such a fantastic talk. And we are looking forward to hearing you right away. Thank you, Faisal. Please start.
Thank you, Colin. And with so many people here, I feel like a legal celebrity. Although I don't know whether what I talk about today has any legal value or not. I have my doubts about my own presentation, but let's start. Uh, so the topic today is the concerning the litigation we did regarding the Baldia factory fire, which occurred in 2012 in Karachi, which is a city in Pakistan. So what I'll do is that I'll divide my talk into three parts. The first part is that I'll give a brief description of the various legal proceedings and their results uh, of this litigation. And of course, the connected development regarding the mobilization. Second part would be about the root law from this litigation. And specifically in that, I'll be talking about two paradoxes which I discovered while I was doing justice and injustice and the coexistence between lawfulness and lawlessness. The third part of my talk would deal with the issue as to the question whether in matters of labor law can human rights public interest litigation be effective or not? Can it bring about? So these are the three basic parts in which I'll divide my talk. Now, why is the Baldia factory fire important in terms of labor history? It is important because of the tragic consequences of this fire. As a result of this fire, 255 people were burned alive and about 55 were injured. There are still controversies regarding the number of deaths and injured, but this is a kind of an authentic figure. So, as far as I'm aware, when it comes to deaths from a factory fire, this is the largest number of people ever killed in a factory fire as a result of a factory fire. Now, when this happened, we of course then decided to initiate litigation on it. As you would all be aware, of course, the normal route of litigation when it comes to compensation for victims is to file tort claims. But we decided against that because it was impossible to file 255 tort claims or even combine them together. And for the 55 injured people in this fire. So what we did is that we initiated two public interest litigations in the Sindh High Court. Sindh is the province in which Karachi is located. And the basic objectives of that public interest litigation were four in summary. First, of course, was to get compensation for the victims and their families. The second was to have the constitution of a judicial commission to investigate who was responsible for this fire, and of course, suggesting future steps which can be taken to prevent such fires. The third was, which was uh, quite central to this litigation, is that we knew that there was large scale non-registration of factories, and there was large scale non-inspection of the safety standards of factories. So these were the four objectives. Now, to cut the story short, what did we achieve out of this litigation? The first problem which we faced is that the state uh, was, for unknown reasons, not able to even identify all the bodies. So it is through High Court orders that all the bodies and all the injured were identified. Now you can understand why that is so crucial for compensation, because unless you have identification of the dead and injured, the compensation cannot be dispersed. So this litigation went on from 2002 to 2012 to 2016, and as a result of various orders and as a result of the constitution of a judicial commission for compensation, we were able to disperse about 18 lakh Pakistani rupees to each of the family within a space of thing which came out of this litigation. The second was that the High Court ordered about 1,000 factories to be registered by the Labor Department, and hundreds of inspections took place as a result of this litigation. Uh, there were, one of the reasons which I'll explain later, one of the reasons why there was such a large number of deaths in this factory fire is because of the fact that this building had illegal structures, had illegal floors, which collapsed when the fire started. So various orders were passed regarding the inspections and violation of these building violations in these factories. Apart from that, as a result of this litigation, uh, you might not be aware that before 2017, the only law which dealt with occupational safety in Pakistan was the old colonial law, the 1934 Factories Act. As a result of this litigation, the government uh, initiated and enacted a new law on occupational safety in 2017. Uh, in 2016, another important development took place, is that we took our grievances to Germany and to ILO, because the major buyer from this factory, about 80% of the goods of this factory, were bought by one German company, which was called Kaik. So we took our grievances to Germany. Our friends in Germany, which Colin is aware of, the European Center for Constitutional and Human Rights, also initiated tort claims in Germany. We took the victims to Germany, we mobilized there. So as a result of that, this matter was referred to the ILO in order to decide about this. 18 lakh was the initial compensation, to decide on the issue as to long-term compensation, which is basically pensions. And as a result of that, negotiations, which was negotiated on behalf of our partners, the Industrial Global Union, as well as the Clean Clothes Campaign, who negotiated on behalf of the victims. And of course, there was Kaik on the other hand. Uh, Kaik agreed, which is the German company, agreed to pay a further compensation of $5.1 million, which was to go towards long-term pensions to the victims, which has now been implemented in Pakistan under the Sindh Social Securities Institution, which is dispersing this lifelong pension. The importance of the ILO intervention also lies in the fact that instead of uh, invoking and implementing Pakistani law in terms of the minimum wage, they invoked their own convention, which is C-121 regarding compensation. So the victims ended up with a pensionary claim which was about 40% more than what they would have achieved if the local Pakistani law had been made a basis of this long-term compensation. So this is what came as a result of this litigation. Uh, there were, of course, criminal proceedings which were also initiated, not against Kaik, of course, but against the owners. Uh, and these criminal, the basis of this criminal proceedings was that the owners were charged under Section 300 of the PPC, which is basically under the uh, third part of Section 300, which is gross criminal negligence. And not only the owners were charged in these criminal proceedings, but the negligent government officials from the labor department, people who were in charge of looking after the building inspections were all part of the criminal proceedings. So this was what you can call as the uh, gains from this litigation. But what did not happen as a result of this litigation? What did not happen is that when this factory fire took place, you'll be surprised to learn that there was not a single strike by any labor union, either in Karachi or in Pakistan. Uh, this is a factory fire which has killed the largest number of people recorded, and there is not a single strike, which showed the state of unionization both in Karachi as well as in Pakistan. So, what did not result uh, as a part of this litigation was that we don't see after 2012 any improvement in unionization, and this is a factory which had no union. It had no union. It wasn't even registered with the labor department, uh, even though it had over 2,000 workers working there. So the second thing which did not happen is that although we got quite substantial compensation, which is the initial compensation, about 18 lakh Pakistani rupees for each family, but this was all ad hoc, this was all voluntary, this never became a part of any long-term labor reforms in terms of reforming the laws regarding compensation in, in relation to such tragedies. Number three, although this huge amount which we got as a result of the ILO negotiations, the $5.1 million, which went to pensions for these families. But this was a voluntary arrangement, so no social security reforms took place as a result. Although initially we were able to, as I said, we were able to register around 1,000 factories. There were hundreds of inspections. But after that, nothing really happened in terms of registration as well as inspection regarding occupational safety. So these are the two dramatically opposed consequences of this litigation, which I will later explain what I call tactical gains that we tactically gained but we strategically and structurally lost in this litigation. The most tragic part of this litigation, which we were hoping to achieve, was some kind of accountability of these owners, which, if we had achieved, then it would have really had a long term impact on the uh, industrial and capitalist class in Karachi or in the province of Sindh at least. But what happened in the criminal litigation was even more tragic. Although initially they were charged under Section 300 for gross negligence, both the owners as well as the government officials. And the reason for that is very important, is because every every initial investigation which took place, both by the local police as well as by the federal authorities, which is called the FIA, the Federal Investigation Authorities, came to the conclusion that it is not the fire which killed such a large number of people. It is other reasons which killed, which led to such a large number of deaths. The first was that this factory had no safety standards. There were no fire extinguishers, there were no fire alarms, uh, there were non existent fire safety practices amongst the workers. So, when the fire started, there were actually no mechanisms uh, within the factory to stop the fire or to extinguish the fire. The second reason why there were such a large number of deaths was the way the factory was operated. This was a two-floor factory with a mezzanine floor, and what the owners had done is that they had permanently sealed all the windows, and they had permanently sealed all the doors except one door, on the pretext to stop goods being stolen. So when the fire took place, there were actually this single door through which the workers could escape. The third major reason for such a large number of deaths was that they had built an illegal mezzanine floor, which was actually of wood. So the fire started in the basement. And when the fire reached the mezzanine floor quickly burned and fell on the ground floor and the basement, and all the workers on the ground floor and the basement was trapped. So the initial investigations were right in identifying that these large scale deaths, there might have been some deaths, but this large scale deaths of over 250 workers would not have taken place if these deficiencies would not be there. That is why the owners and the negligent government officials were charged. But what happened in the criminal trial is that initially they were all charged, but then the Prime Minister of Pakistan intervened, and he instructed the investigation officer that he should sympathetically look at the case of the owners. This is within 6 months of the fire, when even all the dead bodies had not been identified. And what the investigation officer did is that he converted the charge from Section 300, which is a murder charge, into Section 322 of the Pakistan Penal Code, which is a manslaughter charge. So under Pakistan Sharia law, for manslaughter, there is no jail sentence. So all these owners and government officials got bail. Uh, and this is what I say, that the criminal case started from hope, and then it was really converted into a comedy. But the tragedy did not end there, is that the owners realized that even some criminal liability even in the form of manslaughter would be a problem uh, for this class as a whole, the industrial class as a whole. So in 2016, the state, in collusion with these the association of these industrialists and the capitalist class in Karachi suddenly discovered, both the state and they discovered, that actually the fire was started deliberately, and it was started by a political party called the MQM, against whom at that time a state operation was going on against the militants of the MQM. And they converted the entire case of gross negligence of the owners and the government officials into a case of terrorism, where workers of the MQM were accused of deliberately starting this fire for purposes of extortion. Now, of course, I've examined all the evidence and there is actually no proof for that. But what this did is that it completely rehabilitated the owners. It completely rehabilitated the government officials. They actually now became complainants in this factory fire case, and the accused were these workers of this political party. So the perpetrators, who through their gross negligence, the owners and their colluding government officials, had been responsible for the death of so many people, but actually now became complainants in this criminal case. So this comedy was now converted into a tragedy. So this is really a brief description of the litigation and the events regarding the Baldia factory fire. Now, when I looked at this, I recently wrote an article, long piece on this Baldia factory fire and what are the lessons which we learn about the law and human rights litigation regarding this. I've come to the conclusion that what the law has is what I call two paradoxes at the heart of the rule of law. Two paradoxes, two dialectics. The first paradox is what I call the coexistence between justice and injustice. Now, this is best explained by a very important piece written by E.P. Thompson in his book Whigs and Hunters, which is about the Black Act of the 18th century. There is this, in the last chapter, there is this section on the rule of law, in which what E.P. Thompson describes as the systematic contradiction within the notion of the rule of law. And he says that, of course, one of the purposes of the rule of law is to sustain the hegemony of the capitalist class. But it can only sustain this hegemony. It can only be legitimate if at the same time it has some notions of equity, it has some notions of justice. So these two elements of justice in the form of the law, also having some form of equity, some form of universalization of rights, at the same time also serving the purpose of sustaining this capitalist system, these coexist within the rule of law. And this is what we noticed in our litigation of the Baldia factory fire. What I've described both as the gains and the losses of the Baldia factory fire, I see those gains and losses in terms of this inherent paradox, in terms of this inherent dialectic of justice and injustice, which is inherent in the rule of law. So, to make this theoretical insight concrete, we were only able to get such large compensation, some registration, some inspection, some initial breakthrough in the criminal case, the ILO intervention, this new law, if we at the same time, this is what I call limited justice. we were able to achieve this limited justice only if at the same time we were not if we were not willing to challenge what I call the structural injustice. So we got all of this, but it led to no long-term reform. Even the law which was passed in 2017 regarding occupational safety has hardly been implemented. And it has so many flaws that it will take many decades to rectify those flaws, let alone implement that. So these gains and losses have to be understood, I think, in terms of this very brilliant concept which E.P. Thompson has given in that book about how the rule of law at the same time sustains both justice and injustice. And this dialectic uh, exists at the same time. To borrow from the literature of nuclear weapons, this is what I called mutual coexistence. They guarantee each other's existence. So if you only want limited justice, the law is willing to give you that as long as you don't talk about any kind of structural injustice. And the structural injustice is willing to tolerate limited justice as long as uh, no large scale, long term, permanent reforms take place within labor law. So, this is the first paradox, I think, which I discovered while doing this litigation. But there is a second very interesting paradox which one discovers while looking at this litigation, is what I call the mutual coexistence and mutual uh, guaranteeing of each other's existence of both lawfulness and lawlessness. This is, of course, not a concept which I have invented. It's a concept which I take from uh, 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 Jane and John uh, Kamaroff, who've written a very important book on this, Law and Disorder in the Post-Colony, where they describe, when they talk about South Africa, how this great architecture of what we call modern law, what we call constitutional law, with all its fundamental rights, with all its human rights, coexisting in reality with a huge path of lawlessness. So we have these formal structures of law with some implementation of the rights and duties given in these laws and in the constitutional provisions regarding fundamental rights and human rights. But these are only what can be called islands of uh, legal implementation. They coexist at the same time with the non-implementation of labor laws, non-implementation of fundamental rights and human rights at the same time. And the reason why they are able to coexist is what we saw in the Baldia factory fire litigation, is that they reinforce each other's coexistence. They tolerate each other's coexistence. One lawfulness is some lawfulness, some implementation of labor law is able to happen only if it doesn't want complete implementation of labor laws or effective implementation of fundamental rights regarding labor rights. Uh, and the lawless side, which the hegemony of the capitalist class encourages, is it tolerates some implementation of the law because it thinks that if we don't even allow that, then the whole structure may collapse. So there is, using the same logic, there is a kind of mutually assured, guaranteed coexistence of both lawfulness and lawlessness. Uh, and I don't see a resolution of these two paradoxes within the current form of the rule of law. Now, just to give you one quick example of why I say this lawfulness and lawlessness exist simultaneously, it's very interesting to compare the Baldia factory fire with a fire which took place about 100 years ago in America, the 1911 uh, fire in New York. And if you compare what happened in New York with the Baldia factory fire, you'll be amazed at the similarities between the fire. The reason why so many people were killed in the New York fire in 1911 are almost identical to why so many people were killed over 100 years ago. The same issue of the permanent sealing of doors, no fire and safety conditions. Uh, it's amazing the similarity. And if you look at the consequences, criminal trials took place against the owners. They were all acquitted. The victims were, of course, successful in the civil trials in New York, but the owners were required to pay uh, compensation, which was much less than the insurance claim which they got from the insurance company. So one needs to ask that even after 100 years, when you have this whole infrastructure of labor laws and labor rights and all these institutions which have come up with the labor departments, the social security departments, you have all these fundamental rights in the constitution. You have constitutional remedies in the form of the high courts in the Supreme Court in India and Pakistan. Why do you have the same events happening again and again with remarkably the same consequences, nothing really coming out of that in terms of any long term reform, any accountability? Uh, and that is why I come to this conclusion that these two paradoxes of limited justice and structural injustice on one hand, one paradox, and lawfulness and lawlessness coexisting at the same time is what explains the repetition of such fires even after 100 years. Now, quickly to the last part. Now, what lessons should we draw from this litigation in terms of the insights about the rule of law, which I've explained? I think it's important for labor lawyers and human rights lawyers to be clear about uh, what objectives they want to achieve out of this litigation. Now, as you know, there's a whole literature about uh, what can be achieved out of human rights litigation, and it really revolves around a very famous book by Rosenberg, the Hallow Hope 1991-92 publication, where he shows skepticism about whether law and judges or the judiciary can bring about social change. Of course, he's changed his position to a certain extent in a book which he wrote about the Indian Supreme Court, where he talks about a qualified hope. Uh, as a result of that book, there was, of course, uh, skepticism about whether law can really bring about any social change. Uh, People have come up with various kinds of solutions. Some have talked about that it doesn't matter if you don't achieve victory. If you have success, it is still victory. You know, if you can show resistance. There are other people who have talked about that there can be winning even if you lose, if you are able to mobilize a lot of people, if you can energize organizations regarding uh, various kinds of social reforms. There are people who have talked about rebellious lawyering as a new form of public interest litigation. Uh, at the moment, at least in terms of my thinking, I wasn't interested in this. What I was really interested in is whether judicial wins, winning cases through the courts can have an impact on social change. And I think in order to understand that impact, you have to divide your victories into three separate categories. One is what I call tactical victories, the other is what I call strategic victories, and the third is what I call structural victories. So, what are tactical victories? Tactical victories are victories which we gained through this litigation. So, we were able to get substantial amount of compensation for the victims, uh, a lifelong pension for the victims, but really without any kind of major reform. Yes, a law was passed in 2017, but to me, these laws have become very deceptive. The reason being is that whenever a government is faced with any kind of such tragedies or major social mobilization, what they do is that they simply pass a law. And that is what I call lollipops. They know that these laws will never really be implemented. There aren't any effective institutions to implement that. There are all kinds of wishes in the law, which there isn't a state structure to implement all those wishes, all those desires which are in the law. Uh, Moreover, these laws always have fundamental flaws, like the 2017 occupational safety law, and these uh, flaws are then exploited by a very powerful capitalist class to stop the implementation of these laws through the judicial process. So, yes, a lot of tactical victories, which I've described, but I think no strategic victories. Uh, Strategic victories would have happened in this case if we had connected our tactical victories with strategic aims. One of the two basic aims of this litigation was some kind of accountability of these owners and government officials, and we failed in that. The other strategic objective was that we wanted to use this litigation to have effective registration, large scale registration of factories, as well as inspection of these factories. Now, it we initially started on this, but this objective went in the background. The accountability of the owners went in the background. And the reason for that is that none of the stakeholders, especially the victims, were interested in accountability as a priority. They were not interested in labor reforms as a priority. Their main focus was on compensation. And we got so consumed and obsessed with compensation that we forgot those strategic objectives, which could have created space for future labor reforms. As far as structural victories are concerned, I think it was a complete failure, this litigation. And the reason is that if you have a litigation in which ultimately, by the collusion of this capitalist class with the state, they are able to completely convert this tragedy into really a gain for themselves. They were the perpetrators in the beginning, they were responsible for the large scale deaths, and they ended up becoming complainants in the criminal case. The entire public discourse about this factory fire changed. It changed from a tragedy which resulted because of a lack of unsafe conditions, lack of labor reforms, into a terrorism case. So it's quite paradoxical that this tragedy took place on uh, 9/11 2012. So it actually shares two common characteristics with the 9/11 attacks in New York. It happened on 9/11 in a different year, and ultimately it was converted into a terrorism case. So really, the very powerful industrial and capitalist class in Pakistan had the last laugh. They were able, even after this tragedy, they were able to prevent any kind of major large scale labor reforms, even large scale inspections of their factories to take place. Now, to conclude, what the ultimate lesson from this case, which I draw, is that uh, we have to abandon two positions, which is usually taken in the literature. One is of legal nihilism. I'm not arguing for legal nihilism. I'm not saying that you abandon the courts, you abandon the law. And the reason is very simple, is that if you look at this litigation, it is not as if you did not have any victories. You had tactical victories, which could have been converted into strategic victories, but no structural victories. Uh, so I think the position of legal nihilist is wrong. But on the other hand, you have people who are too optimistic about the law and the judicial process, and they think that if we keep at it incrementally, there will be major reform. Uh, I'm very skeptical about that. And these are comments which I make within the context of labor law. uh, my ultimate conclusion about this case is that you cannot resolve these paradoxes within the rule of law. This paradox of justice and injustice existing together, lawfulness, lawlessness existing together, you have to live with this paradox. You cannot transcend this paradox within this current modern judicial system. As strategic lawyers, what we need to do is to exploit these paradoxes in order to increase our tactical victories and to connect our tactical victories to strategic victories. I think that is the most we can do as a result of this litigation. Thank you. I'm finished. I
Yes, Faisal. Thank you. We could hear you quite clearly.
Sorry, there was a lot of stuff which I had to cover in half an hour. That is why there might be a bits of confusions regarding the lecture, but there were time constraints, of course.
Can you put on your video, Faisal, please? Let's see if we can
Sorry?
see you now.
I can see you.
Can you put on your video, please? We'll see.
I've put on my
Yes.
video, Colin.
Yes, sir, I
Your
can see
video.
you.
Yes.
Gracias. The video without your. Where is it? Yeah, we can't see you there. Video, Siddharth says his video was on.
Yes, ma'am, I can see you.
Just a second, just 1 second. Could be not there. Faisal, that was Ah, can you see now?
Yes, yes.
Can you see now? I can.
I think he will. So Faisal, can I ask you a question?
Yes.
Can't hear.
He's muted.
You're muted.
No, I'm not muted.
Because I'm not muted.
No, I'm not.
Okay, we can hear you now.
I can hear you also.
Again. Hello, can I ask you a question, Faisal? Not a good question. We'll spend a little bit more time doing it properly. We have to organize this properly. Can't we carry dongles and all with us and do it?
We are connected with the dongle. The internet generally in this area is not good. It's okay.
Hello, Faisal, can you hear us?
Yes, I can.
Yeah. Can I ask you a question? And the question is this. Now, after the fire took place and the litigation happened and the controversy broke in Pakistan, are the buildings where the workers are working, small factories, particularly garment factories, are they in any better condition that they today than they were when the fire broke out? Or is it just the same condition?
I think two answers have to be given to that. One is we don't know, because we would only know if independent elections take place. And whatever we know about these factories right now, what we can say is that nothing really has improved.
We've been muted.
Yeah. So therefore, even though such a fire took place and hundreds of workers died, and the litigation got a lot of attention in the national and international news, the conditions of the garment workers in these small scale industries is basically the same.
Yes, and that is why I've talked about uh, understanding that this paradox coexists, that you will get limited justice out of this litigation, but that only happens if you do not go for go, go for some kind of structural justice. It's a compromise within the rule of law which exists.
Right. Now, I take it, I understood that this did not take place through the legal system of Pakistan. It happened through a kind of a mediation or arbitration with some international body which took it up, is it?
The one half of the compensation was a result of litigation in Pakistan, which is the payment of about 18 lakh rupees to each of the families. But as far as long-term compensation, the pension scheme is concerned, that is a matter which was a result of a mediation by the IL.
Are there any other questions? Yeah. Why didn't you ask me? There's a question from a member of the audience that participated. Did the case actually lead to a change in the safety conditions of workers in factories? Have any audits been made part of the legal system, mandatory audits regarding safety in factories?
So,
Like in Bangladesh.
as I said,
How do you compare this with the Bangladesh litigation?
uh, I mean, the key difference between what happened in Bangladesh and Pakistan is, as you know, there was large-scale mobilization of unions in Bangladesh. So there were major strikes in Bangladesh. And as a result of that, changes have occurred. Yes. What happened in Pakistan is that, yes, there were, as I said, over 1,000 factories which were registered, which were unregistered initially. There were hundreds of inspections initially, but that did not take a permanent form, although orders were passed by the High Court, is because in order for that to take place on a large scale, what you need is an effective labor department, which has to be constantly pursued through the judicial process. When we got bogged down in the compensation issue, which lasted for about 4 years, the entire attention was diverted towards compensation. And uh, this issue of registration and inspection could not be effectively pursued. I think that's a mistake which we made. But the reason for that mistake was obvious because the stakeholders who were involved with us did not prioritize the issue of labor reform as well as accountability of the owners as a first priority. It was a priority low down the ladder. The main priority was compensation.
So we have just one more question. We know that there was a certain amount of litigation that was being attempted in European courts under the universal jurisdiction. Has any of that attained finality, and has it meant anything better in terms of jurisprudence for workers from where the goods are being produced for consumption in Europe?
So, as I said, there was this litigation in Pakistan which resulted in these tactical gains in quite a short period of 4 years. But the tort claims which are filed in Germany by with the help of the European Center for Constitutional and Human Rights were actually dismissed at the stage on the point of limitation. So, as far as judicial precedents are concerned, in the European context, no judicial precedents were established.
Faisal, thank you very much.
Thank you. Thank you. Thank you to all.
I hope to see you again soon.
Yes, hopefully.
I hope to see you again soon once once the visas open up and we can come to Pakistan and we can have you here in India. Wait a minute, we want to turn on our video to show you the participants. Just 1 second.
Yes.
I can.
Thank you all.
Thank you, Faisal. Hope to see you in India soon.
Hopefully.
It's okay.
Faisal, sir, can you still hear us?
No, ma'am, disconnected. Disconnected.
इसको कर दो यार, बंद कर दो.